Allow me to reintroduce myself. Now tuned into the greatest.
What's up, people, and welcome to another episode of the Supreme Decisions Legal Minute Podcast. And today, I want to talk about something because it's going to be done today without any background music. And I hope everyone that did not want music has hit that Cash App, because now I'm serving you what you asked for. And I hope it's enjoyable. But today I'm actually going to talk about something because I've been getting a lot of phone calls on it. I've been getting a lot of emails on it, a lot of text messages, a lot. Anyway, it's a state official being sued in federal court and why I recommend suing them in their personal capacity or individual capacity and not attempting to take officers such and such or their office into court. Now, I've spoken about it in the past. Ex parte Young, in 1908, he spoke about the United States Supreme Court allowing the suits of federal courts or in federal courts against officials acting on behalf of states of the Union to proceed despite the state's sovereign immunity. Now, as I go into that, I want you to understand something. I've literally done a couple videos lately that spoke about the one thing that I think is second to none for the most part, and it's understanding clearly established law. Because we know there are only two things that disqualify a state official of sovereign immunity or qualified immunity. And that's deliberate acts or willful acts, which is basically them doing something knowing it is against the law, such as giving instructions to someone because they're taught to take control of a situation and that they are the ones that are the superiors at that moment. And also understanding ignorance, because someone that's enforcing policy is someone that is doing something based on ignorance of the law. And as you and I know, as it has been told in the Supreme Court, that ignorance of the law is no excuse, considering their job is law enforcement. Because if you cannot enforce law if you don't know what the law is, and any action that deals with the enforcement of law outside of what is lawful is illegal. So, again, want to start with that because that is pretty much the foundation of the house today. And in building this, I give you these cases in a manner to where it's easy to understand, it's easy to follow. It also allows you to go deeper in depth of what is needed to win. Because whenever you're looking at these athletes, you're watching these lawyers on TV, you're watching these actors and actresses. What we don't see is the things that's done not on TV. We don't see that Steph Curry's jump shot is as pure as it is because he went out there and performed for an hour and a half. What we're not seeing are the hours and hours and hours before the game. We're not seeing the hours and hours and hours after the game. We're also not seeing all the years of work. We're seeing products of that. This is where I come in. This is where these videos come in. This is where these podcasts come in. Because these are things that we're doing for the hours, because we're sharpening ourselves. We're preparing for battle, because that's what this is. That's why I constantly talk about the adversarial system. I constantly talk about the willingness to fight. I also talk about the ability to understand law is without emotion. Law is just that. It is concise. Words with power. Words used to paint pictures within that power. And also understanding that no one cares about our side other than us. So I'm showing you how to get your jump shot pure. I'm showing you bit by bit so your foundation can be strong. Because we're taking the big bad wolf away. We're building our house with bricks. And that's what each one of these are for. Because each time I give you a little bit more than the last time. And I hate to say I'm spoon feeding, because a lot of people want to jump in. They want to go straight to, and then they hope for no confrontation. But in an adversarial system, in the right to confront one's accuser, that's telling you, you have to fight. One podcast, I looked at it as a boxing match or a championship bout. Why? Because whenever they write that citation, whenever they put you in handcuffs, they are saying, I am ready for a bout. The reason why they give you time to set up is because that's your training camp. This is when you start doing your road work. Each one of these are different aspects of your training, because everything I give you, you're not going to need in every fight. You might need a little bit of this from one fight, need a little bit of that for the next fight, but the main thing is you'll have it. And that's what these are for. Because at the end of the day, knowing what's happening, understanding how to execute, and when you're looking at what needs to be done, you're able to disseminate exactly what is needed and how you need to execute. So, with that being said, we're going to go back to Ex parte Young. And the reason the suits are allowed in federal courts against officials acting on behalf of states of the Union to proceed despite the state's sovereign immunity is because you're not suing them in their official capacity. Because just like I stated in one of the videos a couple weeks back, once they violate or step outside the guidelines of the Constitution in Supreme Court cases, why? Because that is the supreme law of the land. They are no longer actors of the state. They are no longer acting in their official capacity. And once they stop acting in their official capacity, they are no longer protected by the state's immunity. That's why deliberate acts and ignorance are set apart from those that are done with flat out impunity, because they have guidelines in which they must follow. And if they choose not to follow it, the state cannot allow it. I'm going to say that one more time, because even if they're doing something, they know it's wrong or don't know it's wrong, but it is written that it is wrong. Someone has been held accountable for it being wrong. They are then liable. But now they are not liable as Officer Johnson. They're not liable as Lieutenant whatever. They are not liable as Chief anything, because they lost their title the second they violated. That is why you sue them in their individual capacity. Because once this happens, they are no longer actors of the state. They are no longer agents of the state. And Ex parte Young, which allows parties to seek relief against state officials for violations for the Constitution and the laws of the United States, allows state officials to be sued in their official capacity for prospective injunctive relief. Now, what that means is when you're suing them in their individual or state official capacities. That is when the state has stated that their actions are not only lawful, but there is a written guideline that allows for this to happen. Now, the reason why you can't sue them in their official capacity is because there is no state policy that is written that will be handed over to you, or that you can get your hands on in 99.9% of cases, that will illustrate that the officer's actions was allowed by the state. I'm going to say that one more time. Ex parte Young, and remember, this was written in 1908, which allows parties to seek relief against state officials for violations of the Constitution or laws of the United States, allows state officials to be sued in their official capacity for prospective injunctive relief. Now, when it says to be sued in their official capacity, it must be something you can prove. And I don't know how many times I have to say this, because so many people call me and all they care about is, I want them to know my side. I want them to know my side. Guess what? They don't give a shit about your side. They don't give a shit about your feelings. All they care about is the law. And it's not about what you know. It is about what you can prove. And the only way you can prove that a person acted under the guise of the state guidelines is to, one, have the state guidelines that illustrate the action set before you by a certain person was allowed by that state. The second thing is to be within their guidelines, acting in their official capacity. Now, knowing that, knowing once it is done, it set a precedent. No state will have something written that will show or illustrate them blatantly breaking the law. Now, do I think that every state is like that? No, certainly don't. Do I think that every level of government is like that? No, not at all. However, do I think that most will not have it, and those that do have it will not turn it over? Yes. Because at the end of the day, people have been holding these officers and these officials accountable in their individual capacity, because that is the means by which it is understood, because they no longer are actors of the government once they violate the Constitution or federal laws which violate one's civil rights, which are the rights given to you by God. Man cannot give you laws and rights, so they cannot take those rights away. They cannot implement a law against those rights. So therefore, they are held accountable when they are not done properly. Now, I'm going to go a little bit deeper, because if you hear a little chatter in the background, that's because somebody is behind me on a cell phone. But, okay. Now, a lot of times also, whenever you're talking about suing someone in their official capacity, this only applies to state actions against you, which generally means that they are holding actions such as something that you remove from a court, lower court, to a federal court, which will mean prosecutorial misconduct. They can be held in their official capacity because they are acting under the guise of the state, which is why they have things such as harmless error. Now, when they're acting outside of that, that's when the lawsuit becomes for the misappropriation or prosecutorial misconduct. Now, I've also had someone contact me regarding retroactive monetary relief. And even under Ex parte Young, retroactive monetary relief can be granted against an officer sued in his individual capacity. Retroactive monetary relief generally means things that have happened that are kind of sort of outside the guidelines of a timeline of something such as wrongful death. Because I've told you on many occasions, wrongful death is generally 1 year to 2 years, and it begins at the time of death. Most times what people do or happen to do is they'll wait for a verdict, which is, to me, crazy as hell. Because you can actually file, because the actions generally show that even acting in their line of duty, they chose to do the one thing where they had at least 7 other options available to them. And that choice was a conscious choice because it was either practiced or it was policy. And it makes it easier when there's only one side to speak on it. And retroactive monetary relief can be granted against an officer sued in his or her individual capacity. Bringing an action against an officer in his individual capacity does not implicate state sovereignty. I'm going to say that one more time. If you're suing a police officer in their individual capacity, it does not allow them to fall under the guise of state sovereign immunity because you are not taking the official office into federal court. You are actually holding someone accountable for their own actions that are outside the guidelines of one that is in law enforcement. You're holding one accountable for their own actions when they act outside of what is allowed for them. And here's a case that you're going to hear from me on multiple occasions. Edelman v. Jordan, 415 U.S. 651, 1974. It holds that federal courts may grant injunctions against unconstitutional acts, against actions taken by state officers. Now, this is key because a lot of what I'm saying is getting ready to be hitting you in the mouth real quick. I need you to cover your face a little bit because since the officers were acting outside the scope of what a state could authorize them to do, they were stripped of their power and their official actions are as such void. Such relief is necessary to protect the Constitution's supremacy clause. I think I just said that, like literally I say that constantly, and I did say that. But I'm going to read it one more time. Edelman v. Jordan, 415 U.S. 651, 1974. Please hug that case. Review that case. Understand that case. Become one with that case. Because when I'm saying sue them in their individual capacity, this is the case in which I am reinforced by what I'm saying. This is the case that illustrates everything done and how it is supposed to be done and the actions that are taken and the things that are set before us. This is where we feast before our enemies, because anyone acting against your civil rights is not your friend. Anyone that's not putting on that uniform and not doing the job the right way and only working for revenue, is not someone that is working towards your benefit. That is not someone that is acting brave. That is not someone that deserves to wear that uniform. Edelman v. Jordan, 415 U.S. 651, 1974, holds that federal courts may grant injunctions against unconstitutional actions taken by state officers. Now, that does not mean just police officers. That means those people that are, because I think I said the case maybe a couple weeks ago, where I talked about state employees, government appointed officials, government elected officials, and those that are employees, such as police officers. They have an oath of office. They have a fiduciary duty. And since these officers are acting outside the scope of what a state could authorize, here's the catch. Here's the catch. Since these officers were acting outside the scope of what a state could authorize, they were stripped of their power and their official actions. Remember, I told you the biggest words in law are if, and, or. Whenever those are present, those become huge. And in this case, because a lot of times whenever I'm talking about them, and I'm talking about police procedure, I also illustrate that if and, or at least two of those are present in that procedure. Edelman v. Jordan, 415 U.S. 615, 1974. And the reason I keep repeating it is because the brain learns through repetition. You learn through hearing. You learn through writing. You learn through doing. So you learn through application. It becomes something that is stuck in your subconscious. And those of you that want to hear just my raggedy voice, it is going to ring in your nightmares. It's going to ring in your dreams. Edelman v. Jordan, 415 U.S. 651, 1974. Since the state could not authorize them to do what they did, they were stripped of their power, and their official actions are as such void, because you cannot have an illegal act precede a legal act. Because if it's illegal on the beginning, it is illegal throughout, and therefore void. And such relief is necessary to protect the Constitution Supremacy Clause, because the supreme law of the land is what? I'm going to say it one more time. Is what federal statutes, Supreme Court decisions, and the treaties the country are currently involved with. So, their official actions are void. Why? Because they lose qualified immunity by deliberate actions, willful acts, or ignorance. Why? Because they cannot enforce policy. And therefore, it becomes clearly established law whenever there has been a training on their behavior, when there has been a lawsuit on someone else's actions of the same proportion. They know better. This is how we do it, because then the confrontation call comes in. Why? Because this is when they call, why are you being difficult? Why can't you do your job properly? Because it wouldn't be difficult if you did what you were supposed to do. If you were doing the job properly, we would not even have an encounter. If you was investigating properly, doesn't mean I have to participate in that investigation, because I had the right to remain silent. You've got 19 minutes to complete it. You have to have authorization from either myself, which I will never give you, or you have to get a judge to sign off on it, which means you have to have probable cause of a crime and a complaining witness that can be confronted. And 99.9% of the time, they have neither. That's why you have the right to remain silent. Most of us lack the ability because we want to give everybody our side when nobody gives a shit. That's why you need to learn to do what God has blessed you with by giving you 2 ears and 1 mouth. You should listen twice as much as you talk, which is super difficult for me because I yap constantly. I am one of those people. I hate to hear my own voice. And you guys don't even want me to drown it out with music a little bit. You guys actually want to hear this crappy thing. But I do a lot of listening because I want to use their words against them. I want to be the alpha in the situation because I want to be the beginning. I also want to be the end because if one thing people can't do is fight against themselves. Use their word. I mean, here's the thing, because when they read you Miranda v. Arizona, what you say can and will be held against you. That works both ways. What they write down can and will be used against them. What they write down can and will be used against them for their detriment. It is not for their benefit. Because if they are wrong, if they did not do the procedure properly, if they did not perform as properly advised, then one, like I say, they don't deserve to wear the badge. They don't deserve the uniform. But two, I need to hit them pockets because what they're doing in essence is stealing. They are flat out stealing. And like I said, now the one thing I do respect, I understand folks hustle. When someone robbed me back in the day, I appreciated the fact that he had the respect enough to pull a pistol out on him. What I can't respect is someone expecting respect without giving it, and then demanding my hard-earned money without doing the service that I request, the service they volunteered for, the service they swore to God they'd uphold and do. I can't do that. I'm not in that type of charity business. I do not offer those types of quorums. And at the end of the day, when we're talking about what governs their actions, because I even had a guy tell me, oh, well, there's nowhere written that federal law supersedes state law. Now, I've actually shown you that state has no laws. They have statutes, codes, and ordinances, because law does not change from state to state, county to county, barrio to barrio. What does change are statutes, codes, and ordinances. Why? Because they are safety issues. Because speeding is not a crime. It's a traffic infraction. Why? Because it is a safety issue. Their fiduciary duty is to work towards our benefit and to keep us safe. That is why we have speed limits in certain areas. Because here in certain parts of Texas that I'm in, the speed limit is some god-awful number like 85 and 80, and then there's an area in the mountains where it's 60 and 55, and I'm like, why? It's open road. Well, the safety requirement is to be able to see these damn rocks when they falling, or being able to see these damn rocks when they're in the road because they have fallen already. Because if you're going at 80, 90, 100 miles per hour and you hit one of these rocks or boulders that are in the middle of the road, not only are you going to destroy your conveyance, you're going to die because it's probably going to rip your car in half. But if they don't have it in all areas, it's not law. It's a statute, code, and ordinance because it's a safety issue. Jaywalking is not a crime because there is no complaining witness, but it is a safety issue because not everybody understands how to get across the street without getting hit by these folks that have no clue of what the hell they're doing behind the wheel in the first beginning. Now, because we actually talked about standing, we even talked about those being expert witnesses because police officers aren't doing anything unless they're witnessing a felony. If they don't witness it, it's not happening. So again, it's not what you know, it's what you can prove, which is why the law is not emotional. Nobody cares about your feelings. Nobody cares unless you're in Florida. You know, Florida, you know, y'all are exception. So if you're in Florida, ignore that feelings part, because if you feel like you're scared of somebody, you can shoot the shit out of them and, you know, take their life. However, if I'm one of the people on the other side of that, my family knows to sue the shit out you because, yeah, your actions caused my death. So, yeah, I'm going to still have somebody hit them pockets. But understanding the law doesn't care about the feelings. The law doesn't care about your actions. Only thing law cares about is law. The law is selfish as shit, but it's also precise. It's concise. And it is written through the exercise. Notice, I love that. It is written through the exercising of it. Because there can be all the law in the world. You can have all the rights in the world, but until you exercise it means nothing. Because I can actually go out here and talk about bodybuilding, but if I don't exercise, if I'm not lifting any weight, if I'm not doing any CrossFit, if I ain't doing nothing, it doesn't matter. Why? Because my muscles don't benefit from it. Don't get any bigger. Probably get a little softer, get a little saggy, get a whole lot of things I don't like. But I could talk about it. But until there's an exercise done, it means nothing. And in 1972, Congress amended Title VII of the Civil Rights Act of 1964, which is codified as 42 U.S.C. Section 2000E, Chapter 21, Subchapter, looks like 6, to allow individuals to sue state government for money damages for discriminations based on race, color, religion, sex, and national origin. Why? Because most people don't understand the difference between one's race and one's color. You have a lot of discrimination now because of religious practices. You have a confusion of sex right now. And 99.9% of people have no clue about treaties which would illustrate one's national origin. But everybody has an opinion on it, which, you know, I give no shits, because at the end of the day, opinions are like assholes. Everybody's got one, but nobody really cares about it, because I don't care about your opinion. I really don't. But at the end of the day, I can't discriminate against you. I can't make choices for you. I can't force you to do anything. And in a lot of means, what happens is there's a disproportionate exercising of policy against one because of how they look, how they act, how they speak, the clothes they wear. And with me, it's the understanding of that, because nowhere in someone's fiduciary duty does it discuss one's race, one's color, one's religion, one's sex, one's national origin. But it does cover all of that in separate aspects, because at one instance, the Constitution was written in regards to human beings. God gave human beings rights. I'm going to say that once. God gave human beings rights. So when you're talking about God-given rights, it didn't say the rights for this race, didn't say the rights for this skin tone, didn't say the rights for this religion, didn't say the right for this sex, or the rights for this national origin or because of wherever you were placed at on the planet. It just said human rights. So understanding those applications is why those protections are set forth, because the Constitution isn't a Bill of Rights. It's a book of restrictions. So when someone says, I know my constitutional rights, yeah, no, you don't. What you know is there are restrictions that are set forth. The question is, do you understand how to apply and exercise them? Now, with me, I have a lot of people that come back and they say stupid shit to me. And right now I have a very, very, very extremely low tolerance for stupid. I have an extremely low tolerance for what I consider fake patriots, because you want to talk about how you're doing something but you don't do shit. You want to talk about how this is applied but you've never applied it. You want to tell me how to do this case or that case but you never argued it in front of a judge on any level. The issue I have with a lot of people that want to offer me suggestion even on even helpful levels, because I'm an asshole, because I generally, before I reply to a lot of comments, I read them 4 or 5 times because I want to make sure that the context in which I'm responding is how it's construed for the most part. How am I reading it? And then how was it intended to be relayed? Because I know some people are doing it with good intention. I know some people just do it to show me how smart they are. But at the end of the day, I'm putting things out that I have actually used. I'm helping those that I choose to help because I want to help them. I see something that's winnable. I see something that has a purpose behind it. Now, just because you call me doesn't mean I'm going to help you. Just because you email me doesn't mean I'm going to help you. Doesn't mean I even agree with anything you're talking about. I know a lot of people just text me or call me or send me these emails just to vent. I appreciate them. Because a lot of times those emails give me ideas. But at the end of the day, it's understanding the application of law and its intention, which is why whenever I'm doing these and I'm looking at them and I'm examining them, I want to make sure before I respond that I understand your point of view and where you're coming from. So just know that if I sent you an asshole response, it was generally because I took what you said as being an asshole, not as you were trying to be helpful, or even if you were just trying to show me how smart you was. Because at the end of the day, most of the time I don't care. I appreciate it, but I don't care. Because generally I'm not teaching that. Or I have a lot of people that'll put something in the comment section that says, okay, this is what this and that goes with that. Okay, I'm not there. This is not an advanced class. This is the class for those that actually want to learn. This is the class for those that want to make sure they have their feet firmly on the ground, because just because you've studied doesn't mean everybody has. And 90% of the people that I've spoken with, that I've dealt with, that have been doing this for years, they often tell me, dude, you're sending me stuff that I've never seen. Because what most people forget is when I started this particular journey in 2008, even with my name change and all the other good stuff that came along with it, I began studying this on a different level. 2009, I was charged with racketeering along with a couple of my other brethren. And those that you don't know what racketeering is, or RICO, or all that good stuff, don't worry about it, because my case set precedent in Georgia. Myself, along with Alicia Israel, we represent our own interests. My other brother, he got an attorney who sat second chair and who had practiced and had been a successful attorney for years. She understood that she did not understand the law at the level I did. I didn't do this just because we didn't go to trial until 2012. It didn't get serious against us to like May or June of 2010, which is when I sat down, me and my brother Alishwa, we sat down literally 18 hours a day, 7 days a week. We had hard copy law books in front of us. We went to law libraries. We sat in different cases. We watched, we listened to the verbiage that was used. We watched motions that was filed. We looked at their mannerisms. We studied even behavioral issues. Why? Because we understood that we had to practice. We had to get our jump shot pure. We had to get to the place to where when it was time to perform, we were able to perform. We took on smaller cases that allowed us to get sharper. Or more sharper? Okay, whichever one. Yeah, horrible grammar, but you know the gist of it. But it allowed us to get to another level. And in getting to that next level, we were able to not only move ourselves forward, but we were able to bless others in doing so. But at the end of the day, I'm telling you certain things for certain reasons. And even today, giving you the case that I gave you is the cornerstone of why I've given it to you. Because when you're moving forward with these cases and you're doing it in a certain capacity by a certain means, you have to understand I'm attempting to help put you in a place to not only be successful at filing, not only be successful at winning different portions of this, but I'm also putting you in a place that allows you to win. Because just like during our trial, I was asked, how do I feel about the verdict? And my response was, I'm a winner. I don't get up unless it's to win. That is the same way I give it to you. I'm giving it to you in a means of how to win. I want you to understand at this point, you may not like it, you may not like how it comes across, but in this, I'm Phil Jackson. I'm Floyd Mayweather. I'm that guy that knows how to win. I'm that guy that sets the emotion aside because the only thing I care about is the W. So when I say sue them in their individual capacity, it's because once they have acted outside of a certain guideline, outside of their procedures, they are no longer agents. Why? Because the supreme law of the land tells me that. Their procedures tell me that. In order for me to help you become a winner, I have to tell you that. Now, when I say don't take the office into account, it's because 99% of our situations don't allow for that. Not all, but most. Most don't allow for the office to be taken into federal court. But that's okay. But we also understand that when we're suing for money, because I'm going to say this, I've sued a lot. I've won a lot. But the whole inst is not just for money. If I'm suing just for money, then yeah, I don't need to be interacting because most of these bastards are out just for revenue. And if I'm also out just for revenue, then all of us are going to have issues. But if I'm also out to get a lesson, I want to make sure there's a complete understanding because at the end of the day, it's not about money. It's not about money for me because I watch $1 million athletes get thrown to the pavement. They got millions of dollars and they're still getting thrown to the pavement. And they're not even the suspects people are looking for. I've watched $1 million athletes have a gun held to their head in Las Vegas and be told, I'll blow your fucking brains out if you move. I've also watched I've watched police pull a gun out on a 4-year-old child and tell the child, I'm going to blow your fucking head off. Both of those are different ends of the spectrum of money. I'm in the middle of that. I'm not broke, but I damn sure ain't got millions upon millions. So even if I'm suing for $2-3 million, I've watched folks making $15 million a year be thrown to the ground. Most people don't even remember Tyler Perry in Atlanta, DeKalb County, a place that he uses constantly, has been thrown to the ground by because he didn't know who he was, which was bullshit. He's got hundreds of millions of dollars. He was thrown to the ground. So it's not about money. It's about understanding procedure, understanding lessons. It's about teaching them how to do the job properly and not for revenue. But the only way they understand is there has to be a monetary value attached to it. If someone loses their pension, you got their attention. If someone has to retrain officers, you got their attention. If someone has to use discretionary funds that could be used for other resources, you got their attention. Because that is how a corporation apologizes. Because that is what it is. It's a corporate entity. Now, even understanding this, because when you are suing them in their official capacity, because there are a few instances where you can sue the state for their actions, which means that it is written, because it's what you can prove. The 14th Amendment gives Congress the power to override a state's 11th Amendment sovereign immunity for the purpose of enriching and enforcing civil rights of the states. Because again, the state is not the corporation. The state is the collective of people. Why? Because the state has the fiduciary duty to the people. So the people themselves are the state. And that case for the supreme law of the land lovers is Fitzpatrick v. Bitzer, 427 U.S. 445, 1976. Now, remember, most of your cases are not going to be with the state because the state cannot authorize them to do certain actions. And in order for you to prove that the state did authorize it, they are enforcing that policy. It has to be shown or illustrated in writing because it's not what you know, it's what you can prove. Now, common practice is policy. That doesn't make it law. No matter how well it has been used and accepted, it is not law. And most people need to get that understood. Because there are, again, a lot of people that want to talk about certain things. Oh, the police can do this. The police can do that. Yeah, they can. They can ask. They can also walk on their hands. I don't give a shit about the rest of that. Doesn't change their procedures. Doesn't change their policies. Just like people often, well, you need to do a ride-along. Okay, great. I can do a ride-along, but how does that change their duties? Oh, police work is dangerous. That's great. It was dangerous before they applied. Again, how's that change law? If you can explain any of that shit to me, then we can have a conversation. Because me doing a ride-along doesn't change their duties. The job being dangerous doesn't change their duties. Because anybody that tell me, oh, well, they might get shot, that's great. Because, again, I have a friend named John. He's been shot twice at traffic stops for bullshit. Doesn't change how he does his job. He still handles people with respect. He approaches people without putting his hand on his gun. He does things that allows people to go home at night. Why? Because he wants to make sure that bitch is beautiful. Because I'm pretty sure a lot of y'all listen to my podcast where I talked about the Lil Wayne song. Because most police officers, they are afraid of karma. They are not afraid of people. I've actually watched a show called Live PD. And the reason I watched it was because one of the officers that was on it was from Richland County. Richland County is Columbia, South Carolina. I lived in Columbia, South Carolina for almost 2 years. This police officer I've had an interaction with. Why? Because at the time, I did community mentoring. I visited the juveniles in their juvenile detention facility. I spoke with the young men there. I visited with their first offenders, which would be these guys that are in, I guess you would call it a camp. It's a 120-day boot camp where it's just before they get to prison. And I offered them basically counsel. Well, in the interaction of this, I've met a few of these officers. And I have to say, the things I expected in South Carolina, because South Carolina, to me, they're still like 2 days out of slavery. However, I've never had an issue in South Carolina. I've had more than 20 interactions with police officers in kind of situational instances. Never had an issue with Richland County. These guys always came out and they did the job the right way. They did not come out aggressive. They did not put their hands on their guns. Now, I watched Live PD. And one of the officers I was familiar with, which was the reason why I actually even watched it, this wasn't the guy that I had interactions with. This guy on there, he jumps out of his car, he immediately has his hand on his gun, he's aggressive, and he's doing a lot of things, even with the camera there. And I'm like, okay, I wonder how real this show is. So he's having a conversation with the guy, and at the end of the day, he writes the guy a citation, sends him on his way. Now, the citation was for a controlled substance, and yeah, I don't remember the particulars of it, but I know it was for a controlled substance. And the guy had told him, yeah, you can search my car, dumbass. He searched the car, found a controlled substance. Like, why would you do that? Anyway, at the end, it's the one thing that caught my attention. And the reason it caught my attention was the simple fact that he stated, as far as he's concerned, everyone he encounters is a criminal. Everyone he encounters is carrying a weapon. Everyone he is encountering does have an intention to hurt him. That is how he approaches the situation. Now, the reason I bring that up, because what about those that don't have any of that? What about those that aren't criminals? What about those that don't have a weapon? What about those that are intelligent and don't want to hurt him? What about those people? The problem is they encounter those people, and they encounter those people with the same aggression. Why? Because that's their training. Now, is that written? No, it's not going to be written anywhere. Why? Because that goes against the United States Constitution. That goes against their fiduciary duty to fulfill their benefit to you, because they have to work towards your benefit. It goes against that, so they're not going to have that written down, right? So I can't sue Officer whatever. I can sue Ben Johnson. I can't sue Officer Ben Johnson because it's not written. But I can sue Ben Johnson because it violates procedure based on his training. Even though he's trained that, unless I have video of the training, it's not written. So therefore, I can't take the office in there. And I can't use Fitzpatrick v. Bitzer, 427 U.S. 445 1976. And as y'all can hear, I'm getting a bunch of messages right now. But I'm going to finish this up. But not going to hurry, though, because, damn that. They'll deal with it when I finish with it. Okay. Now, because at the end of the day, one of the reasons I also bring up the fact that suing them in their individual capacity is because when you're attempting to sue the officer and it's not written, it's not something that can be proven. Seminole Tribe of Florida v. Florida, 517 U.S. 44 1996. Congress does not have the power under the Commerce Clause to abrogate the sovereign immunity afforded to the states under the 11th Amendment. Which means, since I can't prove that his actions are done based on policy, I can't prove that his actions are done based on training. I can't sue Officer Ben Johnson. I have to sue Ben Johnson in his individual capacity. I have to have his oath of office showing at the time he performed these duties, he had a fiduciary duty to work towards my benefits, where he did not do because of these actions. And therefore, that is the means by which I can be successful. And that is also, it allows my emotions to be taken out of it. Because just because I know Officer Ben Johnson did something does not mean that I can sue Officer Ben Johnson, because it's not what I know, it's what I can prove. Nobody cares about my feeling. Nobody gives a shit about my side. But again, this is why I'm giving it to you. I'm helping that jumper get pure. I'm helping you put in the work. I'm helping iron sharpen iron. I'm helping you get your foundation. I'm helping your feet get firm on the floor when you're talking. You're able to talk with confidence and your chest poked out. Why? Because you know. And the biggest issue is one of the ones I talk about all the time. And it came from Latin in law, and where we talked about how a police officer, for whatever the citation is, becomes an expert witness because, quote unquote, there are law enforcement officers and they do something that allows them to do it. Why? Because of their police report. But the one thing that most people forget about is the three arms of law, which is corpus delicti, which is the body of the crime, which is actus reus, which is the guilty act, and as mens rea, which is the guilty mind, which is the one thing that is the most difficult thing, because that is what intent is. Mens rea. And that is why it is so difficult to win trials for the accuser. Why? Because they have to prove one's mental state. They have to prove what somebody was thinking when they did something. And the one thing about the prohibition of a third party claim or a third party standing is a party may only assert his or her own rights and cannot raise the claim of a third party who is not before the court. Why? Because you have the right to confront your accuser. And how does one have standing? They have to be injured. And a traffic infraction doesn't offer probable cause because there is no injured party. The police officer can't be an accuser. That's why he has to come in as an expert witness. There can be no standing because there is no corpus delicti. Now, understanding that, this is what opens them up for policy issues. Something as simple as doing something either through act, habit, or purpose. If it is not following the guidelines of federal procedure, if it is not following the guidelines of the Constitution, they are willful acts or acts done through ignorance, which eliminate qualified immunity. The state cannot allow for actions that go outside the Constitution because that is their guideline as to which they must act at 100% of the time. Why? Because the supreme law of the land, which is the supremacy clause of the Constitution. I've given you a bunch of other cases, which is Howlett v. Rose and Shearer v. Cullen. But now we have Cooper v. Aaron, 358 U.S. 1, 1958. The states are bound by the court's decisions and cannot choose to ignore them. When you're talking about the states being bound, because the supremacy clause of the United States of America, again, is not a Bill of Rights. It is not a Book of Rights. It is a ledger of restrictions. The Supreme Court decisions are those that outline police procedures. These are the things that make it clearly established law, which means if they're acting outside of clearly established law, they are personally liable in their individual capacities and bound to you because they breached their fiduciary duty. Now, I hope everyone enjoyed today. I appreciate all those that have been donating. As you see, each time we're getting a little bit better. We're getting a little bit more clear. We have microphones. I've got a different laptop. We got the GoPro. We've got a second iPad. We're working on getting better. We've got new software. We've got new plugins. And even with YouTube now monetizing again some of my videos, the donations themselves allow for us to do something greater. It allows us to be greater because the next step now is to get into an office space. And that office space is going to be probably about $400 to $500 a month because I don't need anything elaborate. I just need somewhere to sit down, need some Wi-Fi. I need a place where I can do this on a regular basis every day because I want to continue to sharpen. I want to continue to help build a foundation. I want to continue to do what we're doing. And if you don't have the Cash App, I'm putting the link in the description. Download the Cash App. They pay us both. You know my link on Cash App is Supreme Decisions. Those that use Apple Pay, I appreciate you guys. But also after you do the Apple Pay, send me your name because I want to shout you guys out too. Venmo. Love it. Quick and easy. Takes a couple minutes to get to me, but it works out. And last but not least, and like I said, my guy Noel loves Google Wallet. It's instant. I appreciate it. And it's used for the channel. It's used to build what we have and make it greater. It's used for me to be able to sit down. As you can see, you guys want the hour, I'm giving you an hour. I'm doing a lot of things because you make it possible for me to do them. Continue donating, continue listening, continue watching it, continue making suggestions. I appreciate you guys. And remember, stand up. It's fight time. The more you stand up and fight back, the more their procedures get in line with where they're supposed to be at. And therefore, we have the rights and freedoms that not only we deserve, but that are given to us, not by the city, not by the state, not by police. They're given to us by God, and we get to exercise. So that's all I got for now. I love you guys. Again, keep donating. Let's keep going. Let's keep growing. Until next time.
The shaking colossus.